tarde a todas, boa tarde a todos. Estamos
Good
começando.
afternoon, everyone. We are starting with this panel number 7 of the 8th International HOMA Seminar on Businesses and Human Rights. This panel is called The Need for Framework Legislation in Brazil on Businesses and Human Rights. We are going to discuss here from different points of view, some ideas that are being developed in this field in the dialogue between our parliament in Brazil and the civil society. And this is to be introduced very soon to our House of Representatives. I am Gonçalo Berrão. I am responsible for training, capacity building with HOMA. I also participate in the campaign for the International Binding Treaty. I want to thank HOMA for the partnership. We're going to hear from Gustavo Pessali. Gustavo is the juridical assistant of the Federal Representative Aura Carolina from Minas Gerais with PSOL, Minas Gerais. He's a consultant in human rights responsible for monitoring the fight against the advances of mining companies over the environment. So Gustavo, you have the floor. Good afternoon, Gonçalo. Good afternoon, everyone. Can you hear me? I am Gustavo Pessali. Today I'm here representing the Federal Representative Aurea Carolina that unfortunately could not be here with us. She had health issues, but she asked me to thank HOMA for the initiative and the representatives of the Federal University of Juiz de Fora. Once again, the public university taking on the leadership in the process of democratic advocacy, showing the unequivocal need of universities for the present and the future of Brazil. Certainly, this project will contribute to the qualification of this draft of law that intends to rule the actions of companies on the environment. We believe that projects such as this one should be always carried out based on articulation of different experiences, resistance, and territorial struggle in different parts of Brazil, Latin America, and in the global South. Well, our mandate aims at building collectively a struggle for feminist causes, LGBT advocacy, committing to the defense of the environment, and facing the processes of domination and violence inherent to capitalism, specifically in its neoliberal character. In terms of the implementation guarantee of human resources in the context of companies and their undertakings, we know that there are several gaps in the Brazilian legislation that make it difficult to prevent violations, specifically on the part of transnational companies, the process of reparation to victims. Currently, we are living in the context of the deepening of neoliberalism, the deregulation of sectors that are highly relevant. The central example in the state of Minas Gerais, where we have our activities, is the constant flexibilization of environmental laws so as to simplify approvals, licensings, and attract investments. According to the state government, we need initiatives to unleash enterprises and projects that see the historical heritage as an obstacle for the development, which we think is simply wrong. We establish a partnership between the government of Minas Gerais for a program call Unleash Minas. For immediate, the government of Minas Gerais established a partnership for unleashing projects that had been prohibited, that had been forbidden by the courts of law due to the illegal character of some of the premises. So once again, this makes us doubt the intentions behind this normative. So it's not today, it's not just now that we have been seeing these initiatives, but now we can see the advancement of ultra-conservative politicians committed to passing on all of these unleashing laws. A concrete example are the criminal disasters with the burst of the dams of Savali, of Vale and Samarco in Mariana and Brumadinho, respectively. This led to the death of hundreds of people and animals, the irreversible destruction of fauna and flora in the region, contamination of rivers that are absolutely necessary for the ecological balance and for feeding people in different areas of the state. Violations against human rights leave scars that will get even deeper as time goes by. What we see in our territorial struggles is that the mining companies, some of them public companies, transnational companies, have been using the context of institutional fragility that our country is living and disassemble and gaps in our legislation and norms to expand their predatory activities through strategies that are through mythology of terror, co-opting local leaders, community leaders, that through their also through intimidation of individuals and communities that try to go against their advancements through environment of misinformation, fear, making it difficult for communities to establish a collective articulation, going against any standards that will prevent risk, that will inspect and control their activities with lack of commitment to transparency and the advertisement of their acts, the absence of internal systems of to protect human rights, of provisioning of funds for to pay for contingencies, negligence about the right of a free previous informed consent of traditional communities such as indigenous peoples and quilombolas, using the frailties of the judicial system. And here we are talking about even the prosecutor's office and the judiciary branch to delay the attribution of responsibility and remediation to those who are affected. And finally, the attempt to stress the processes of remediation with the goal of delaying the compensation of victims. There are spreadsheets that coldly precify the lives of people, animals, and plants, each square of land that is potentially devastated. This is not only fruit of our imagination. There was a commission established in the House of Representatives to investigate the crime of Vale in Brumadinho, opening procedures against Vale and 22 people for murder with criminal intent. So this commission that monitored the agreement between Vale, the judiciary branch, and the state of Minas Gerais for the reparation of collective and individual damages, this process made very clear the huge power of the company in comparison to the power of individuals. It was truthful business counter using resources for works that were absolutely disconnected to the needs and interests of the community, such as the case of the proposal of the building a highway ring with clear electoral interests. Part of the resources were destined to local politicians. The municipalities affected in the basin of Parapeba River were not able to decide the fate of the funds, open space for political destination of the values. Another situation that we have been monitoring is the urgent need to build alternative system to capture waters in the Paraopeba River contaminated after the Brumadinho dam burst, producing more violations of human rights. Communities along the margin of the river now see trucks and tractors destroying fences, constructions, characterizing the landscape and the river and their margins without any type of previous consultation or appropriate organization. What we realize is that without a legal framework to treat cases such as the dam bursts in Brumadinho and Mariana without any guidelines, with hashed process, we will create new layers of human rights violations. This has happened after decisions corroborated by judiciary agencies that instead of acting as inspectors become intervenients, managing part of the resources earmarked by the reparation process. So those who are most affected are the vulnerable parties in civil society. This is to confirm the need of standards and legislations that force companies to establish process of previous informed consent and the inspecting the actions of transnationals. This is the only way that we can prevent this process of this failed process of reparation of damages. Due to the severity of the denunciations that arrived to us, we see that the decree of 2018 has failed, establishing only general guidelines that may or not be adopted by the companies. The absence of the binding character make the proposal even more failed. We could not expect good results from a normative built without a debate of civil society, without the active participation of official movements. This is a mistake that this new draft of law cannot fall into. Our proposal from the federal government is also inefficient. In addition to voluntary commitments, they lack in effectiveness, as we have observed in other countries in Latin America, because the content based on the guiding principles published by the UN cannot close the gaps existing in terms of accountability by transnational companies. So here we are living one of the multiple steps that we have taken in order to establish a draft of law that will be debated by all the stakeholders to protect our people from the strength and violence of mega companies and mega projects. We still have a working group today to prepare draft of law. And this group is formed by Aura Colorina, Fernanda Melchiona, Carlos Veras, Elder Salomon, but also the professors, students, and researchers of Roma, the Friedrich Ebert Foundations, MAMBI, CUT, Friends of the Earth Brazil, UNESCO, Conectas, the Federal Prosecutor's Office for the Rights of Citizenship, Justiça Global, so many movements and activists concerned with the topic. So our desire is that this seminar is a place of exchange, of collective construction, of the democratic legitimization, that the resistance and the willingness of so many social actors in the pursuit of a more solidary struggle can bear fruits here, that the seeds sown by us will then leave in our office. We are available to build new pathways for this proposal. So let's move on. Thank you.
Muitíssimo obrigado. Eu te agradeço muito, Gustavo.
Thank you. Thank you, Gustavo.
Fala contra pouco os motivos pelos quais nós estamos discutindo isso e os
Because you address some of the reasons why we are discussing here. Your arguments were really well built. Before continue, I would like to return to the video. Fernando told me that everything is fine now. Let's see Carlos. I'd like to greet all of you. I'm Carlos Veras, Federal Representative, President of Human Rights and Minorities Commission here in the House of Representatives in Brazil. This topic has been discussed by the Commission of Human Rights and Minorities in the context of the RP1, especially in terms of the responsibility of states and transnational companies about the impact and their impacts on social, human, and environmental rights. Transnational companies have more money in many cases than the countries themselves, and they cannot devastate our lands, as was the case of Mariana and Brumadinho in Brazil. Our struggle is to make sure that social, human, and environmental rights are respected. Therefore, hence the importance to develop this agenda, to evolve this pact, this commission, the situation of this agenda in our parliament. Thank you. A very clear message and the political will. So I thank you for the opportunity, Carlos, for sending the message.
Então, Fernanda, gostaria de pedir para você, mas antes vou te apresentar.
Fernanda, I will introduce you properly right now. Fernanda Caldas Jorge is a partner of LBS attorney law firm, and it's a member of the LADO network, specialist in transnational labor law from the University of Castilla de la Mancha, representative of CUT. And as you know, in addition to a very important work in the human rights councils, this is the largest federation of unions in Brazil, representing a high number of workers in Brazil, has been very active in a human rights debate, labor rights, vis-a-vis transnational companies. So I want to invite Fernanda for her contribution.
Good afternoon, everyone. Can you hear me well? So I thank you, I greet you, all those involved in this seminar, in this project, on behalf of FES Brazil and OMA. Thank you also for the invitation for CUT to be represented here. CUT has a commitment, it's part of its constitution of fighting for an improvement in living and working conditions for the working class in general, and to act, to work toward the consolidation of democracy in Brazil and the transformation of our society. Clearly, within that framework, one can explain CUT's participation on the National Human Rights Council and the involvement and the priority that could lend to this bill to have an effective implementation of human rights in the country. We are experiencing a moment, as Gustavo mentioned, and I think, I'm sure that this was discussed over the course of the last few days, a moment where there is a prevalence of neoliberal ideology under the argument of the need for modernization, brings about a series of so-called flexibilizations of social rights, particularly labor rights in the country. And we are living through a political and a legal setting where this deconstruction, this disassembly of our system and all the advances brought about by the Citizens' Constitution of 1988 are being undone in a project that prioritizes financial capital and disregards totally lives, dignity of these lives, with complete freedom for any kind of business venture. So in this conjuncture, in this setting of deconstruction of rights, of what our Constitution sets out, whether through legal decisions or legislative changes, so the strengthening of Brazil's international commitments and the institutionalization of public policies and structures, state structures, not government structures, becomes even more important. Hence, the importance of the activities of the National Human Rights Council and this network to build this bill with a view to having a law. So there is this dispute between international binding norms and on the part of corporations, the idea of, guiding principles, non-binding guiding principles, voluntary guiding principles. And this dispute and this counterposition is very similar to what takes place between capital and labor generally, vis-a-vis social rights in our country and globally. So in this political context where we are losing access to systems and the demandability of rights, it is therefore very important to reaffirm this access, the inviolability of this right. We've witnessed the destruction of many public policies and even of structures, of consultative structures, as are the national thematic councils in Brazil. So for CUT, it's a priority to fight on this matter, hence our gratitude for the invitation and the importance of the intervention on this matter. As Gustavo talked about the environmental disasters and consequences they brought about, require the protagonism, the leading role of the affected populations, and the contribution we feel as the CUT Labor Congress that we put on the table is the protagonism of workers. One of the traits of this new reason in the world, this ideology centered in capital, is to disseminate the idea, this propaganda idea that work is dying, and to make invisible people that do work. So we identify in this bill, which would be about making human rights more effective and actual in Brazil, we identify in it a very important instrument or tool to build an ecology of labor, a system that is centered on the dignity of people, particularly working people. And so this factor cannot be forgotten because work has an identity, a belonging factor for working people. It's like a ticket into citizenship. So Brazil right now is facing high unemployment and other consequences of the pandemic, including hunger. We've returned to the UN hunger map, and so it's important to surpass this combat and surpass this destructive animus of the governments of the moment. So this is our grounding, this is our political grounding for being present here. And so the contribution that the CUT can bring to this group, and Gonçalo had asked me to speak in my initial remarks to explain the political participation of the CUT and try to underline the fact that this is a priority, how much it's a structuring item of the agenda of our Labor Congress. So we are developing a discussion about the structure of this bill. So that's where I will, that's the point I will address next. Just a minute. So the Federal University of Juiz de Fora, through Roma, does very good analysis and research on the national action plans the world over, and show the fragility of these plans that tend to prioritize the trend to be very generic, very broad, very encompassing, and transfer the responsibility to corporations and their voluntary adherence to the plan. So discussions have been guided to the creation of a bill that should be very well systematized, where beyond the normative principles, there should be a description about the obligations of the state in its role of promotion, prevention, promotion of human rights, prevention of human rights violations, partly discussing also the obligations of corporations and employers in general. And the state, once again, is important because it's an employer as well, and of mechanisms to have the actualization, the effective actualization of the human rights on the basis of international commitments taken on by the country, and the implementation of the national policy with mechanisms of monitoring, with the active participation of society, whether through the justice system, the prosecution service, the public defenders offices, but of society in general, with trade unions, and also a chapter specifically with the protagonism of the affected populations, spelling out their rights, and something more procedural about the active access to justice, both nationally and more broadly. So the main concern, therefore, is that we have to strive to make sure that the Brazilian plan, national plan, not be co-opted by this idea of irresponsibility of the companies, which are given the option of joining, of opting in. In other words, we want the responsibilities to be binding and to be spelled out clearly. And so after the reforms, the regressive reforms that have been adopted in recent years in Brazil that seek to destroy our protective system of the dignity of people, which is a constitutional precept in Brazil, the structures that ensure this have been destroyed systematically in recent years. So it's important to take a decisive step in the opposite direction, which is to rescue the Brazilian citizenry and with a pro-citizen, pro-people outlook. I think for the opening remarks, that's it from me. So thank you once again for the invitation. We are here on behalf of CUT at your disposal. Thank you, Fernanda. Thank you for your remarks and the expression of CUT's wish to continue part of the process. We had now wanted to show Fernanda Melchiana's, Congresswoman Melchiana's video. Unfortunately, she's unwell, she's ill, she couldn't even record the video. So we, of course, wish she feels better soon, but we can't have her participation. But we do have another video from Congressman Elder. Okay, we can show that, and then we start the debate. Elder is a member of the Workers' Party for the state of Espírito Santo. Beyond our panel members, we have in the room some of the people involved in the formulation of the text: Felipe Faye, Chena Masso, Manuela Roland, who took part in the process. I don't know if my colleague Andressa Soares has managed to return, but she also took part in this draft. Chena, you can stay here, please. So we will now watch Elder's message. I invite everyone to use the Q&A function or to raise your hand to be able to make a comment or question orally. Okay, Fernando, the video, and in the meantime, participants can write their questions.
Sou Helder Salomão, deputado federal do Parlamento Brasileiro.
I'm Helder Salomão, member of the Federal Congress, National Congress of Brazil. Brazil in 2007 took on various new obligations as part of the Universal Periodic Review, including to prepare a national action plan for corporations and human rights. So few steps have been taken since then. Brazil needs to advance very much in this debate in sync with the international community. Here in Brazil, there have been frequent environmental crimes practiced by companies, committed by companies. The most recent and most symbolic ones were the crimes that occurred in the state of Minas Gerais, in Mariana and Brumadinho, with major dams bursting. After these crimes, there was no reparation of the families affected. There was no economic reparation, there was no social reparation or environmental reparation. And so there is a difficulty to ensure that companies that commit these crimes, social and economic crimes, should be duly punished. There's a difficulty, there's a major impunity. So we consider it very important to have this debate with Brazilian society to advance in the formulation of a legal framework that is broader, more rigorous, and more in line with the principles of the international community to make sure that we can actually effectively have a new reality in Brazil about corporations and human rights. It's nice to hear Congressman Elder. He was one of the first that got involved with this formatting. There's something we have to say. There's a question here already on the chat. What is missing for the parliamentarians to advance? No, it's not that there's no involvement with parliamentarians, with processes or with cases. What happens is that we found a certain system, these violations. And for some time, not a long time, but the problem is starting to be worked on in specific ways. So I recommend you, by the way, a book that OMA produced where they talk about this. How is the process? What is the situation in terms of human rights and corporations in Brazilian law? And how what is missing is what civil society and various parliamentarians want. There are important parliamentarians here involved, committed to this process. But it's a process that is growing, it's very complex, and there aren't many Congress people that want to work because it means a certain limitation of economic power. And I think Fernanda said it's part of the constant struggle within the capitalist system between capital and labor, the haves and the have-nots. That's the constant struggle. So not many have the courage or the wish to pick that fight. But there's a growing awareness of the subject, and the fact that we're discussing this today is an evidence of that. So among the panelists, I have my dear friend and colleague, Professor Manuela Roland, who wants to ask a question or make a comment. Hello, everyone. Thank you, Gonçalo. Thank you, Gonçalo, Fernanda. We had talked to the other Congress people, they in the last couple of days, they were not able to attend. But I want to talk about the work that's been done. There's a discussion with parliamentarians that reproduces an international process with other networks. There are parliamentarians in other countries taking on this idea. So this happens in many countries and also internationally. We talked about in the previous session of negative experiences that are happening internationally and nationally that are lacking in elements that we would like to not reproduce here. So these these alternatives must be effective, since we're talking about regulation. So I'm going to raise a couple of points. So OMA is part of the working group on corporations, which is made up of more than 20 organizations that for a long time has been trying to raise the question of human rights and corporations from the point of view of affected populations. We have a partnership with PFTC, Gonçalo knows this well, We had the first public hearing we helped organize, and of course, this was called by PSDC with more than 100 people, affected populations, the second seminar of evaluation of the Pio Doce case in the Federal University of Espírito Santo. And right after, we produced a technical note, a paper, a technical paper. Something that was shared was that the corporations dominate the territories, like what Gustavo said. This is a practice both in terms of prevention and non-reparation of human rights by corporations, which benefit companies with a whole framework of impunity and puts them as protagonists of the process. So the FTC produced this paper, and we, HOMA, continued producing documents of analysis of national action plans, which regulate the guiding principles by many countries. There were many, PFCC is the Federal Prosecutor's Office for the Rights of the Citizenry. And so this protagonism of corporations is something that we wish to question. In the previous session, there was a colleague from Poder in Mexico, where civil society left the process of the National Action Plan because the process was completely lacking in democracy, in transparency, etc. So we just want to reproduce the guiding principles with all the problems that that entails. And in 2018, we were surprised by what Gustavo said, which was the 9,571 decree, ignoring a debate that was ongoing, that had been happening, and we had been wanting to raise on various occasions, and we invited representatives of the government. I had a certain proximity with the process, so because I was called to the WhatsApp group to take part in the decree, and I said no. This had to be a much broader call for contributions. And after I made this point in the WhatsApp group, I was excluded immediately. So there was a hearing in April in the Human Rights and Minorities Committee of the National Congress, of the lower house of the National Congress, chaired by Carlos Vera. The government, the Ministry of Women and Families, that they are going to regulate the decree. They would have a ministerial, they would have a ministerial regulation of the decree, and that regulation would be equivalent to the National Action Plan. And there was a whole debate about the decree, about it was not just a process, a problem of form. Sure, form was a problem, but it's a question of content above all. So much so that with the National Human Rights Council, we looked at resolution number 5 in 2020, which is the national guideline. It shows, it's been nicknamed as the anti-decree because this resolution of the National Human Rights Council shows clearly how the decree does not meet the needs. So there is this mismatch right now in Brazil between some advances on the part of the executive versus what the affected populations that are victims of violations, what they are putting on the table. So Fernanda Melchioni has been to UN sessions of the negotiation of the international treaty. The last time we were together in October, and she observed the clamor of civil society and the criticisms made to some of the initiatives, including some of which Brazil is wanting to reproduce. So a person who was there involved, unfortunately couldn't be with us because she fell ill, but just to say that there is an organic, let's say, process happening. So I shared with colleagues that Herbert Vargas, who is the Ministry of Women and Families, published in his social media that the debates of the National Action Plan are already taking place with a view to the OECD guidelines, one to meet the demands of the OECD, and one of the objectives of all this is to obtain Brazil's entry in the OECD. So you can see a complete weakness in terms of what the priorities are. At no moment Brazil says Brazil is one of the worst human rights violators. So 6 years have passed since the Rio Doce river basin environmental catastrophe. Nothing has happened. So we have public hearings about the Universal Periodic Review, many processes of the civil society. We invite the government and they don't send representatives, etc., etc., etc. So we have to connect, network more and more. Something that happened with the law, the due diligence law in France. It's a law that we saw in the previous session that does reproduce certain of the logics of the guiding principles, although there are advances in the law. In other words, we're calling this law not a national action plan, not a due diligence law, but a framework law. We're calling it Lei Marco. So we had these terrific, these horrid episodes. We have the opportunity now of doing something autonomous, non-colonized, with a protective human rights agenda and not just a pro-corporation company. So we need this to join the OECD, to obtain international markets, attract investments, blah, blah, blah. This is a sort of discourse that Brazil has bought into, and this is not the logic that we would like to follow. Thank you for listening. Thank you, Manuela. Before I hand over to Gustavo, I want to say precisely that this kind of law, this kind of policy of initiative, if there's no dialogue, if it's not based on the demands and the needs of society and to remedy actual violations, it has no legitimacy. So it seems like a plan is done just to join the OECD, like a prerequisite to join the OECD. What we're saying is the opposite. We need this because things happen every day, violations happen every day in our territory. That's why we need a framework law. Gustavo.
This is a very complex question. So what do we need for our representatives to take on this fight and to start leading this process? Today, we are leading very much unfavorable political context to fight for human rights. In general, we had situations in which we proposed drafts of law where we raised the point and afterwards the project was completely deteriorated. So after all, the process, after the legislative project was a Frankenstein, completely unconnected to the social reality and people's material needs. I think that today has everything to do with that. Aurea is sick, Fernanda is sick. So we see that the parliament environment, especially in the more progressive field, has been toxic, has been violent, especially for women, Black women, but not only them. For those, everybody that is facing this necropolitics promoted by the government. So it's absolutely necessary in a process such as this one, that we create mechanisms to share our ideas, to deepen democracy so that we can disseminate this destruction as broadly as possible so that it becomes solid, legitimate, and with popular support. This is necessary for us to, in the mid and long term, to offset the democratic deficits that we are going to have to face in the House of Representatives and the Senate eventually. So maybe we can think of the recomposition of the House of Representatives as of next year's election to try to understand the context. I think the idea would be to present the project before, and based on that, try to find as much qualification as possible, maybe with a different composition of our Congress helping us to do that. So we must also share our strengths. Those who are participating here in the seminar, who wish to participate with us in this construction, you are absolutely invited. Let's try to work together. Thank you, Gustavo. What you said is absolutely essential. And I see that Jenna Masso raised her hand. Hello, everyone. It's a pleasure to be here. So I think all the talks have already covered all of this question in a very broad way. This is a difficult topic. And whenever we talk of Roma, we know that we are in a situation of dispute between ideas about due diligence, protection of human rights, things that come from outside Brazil. So there is also this dimension that maybe a law of due diligence for Germany may have some effect. But in our reality of a country that has never consolidated social rights and human rights, it's completely inconceivable, because we know that transnational companies will have a more predatory action here. So it's a field of dispute between different agendas. On Tuesday, we started talking about that, but at the same time, we have a number of mechanisms that sometimes make this discussion easier. For example, in Brazil, we have collective processes. We have instruments and mechanisms such as the burden of proof and things that we must say that also apply to transnational companies. And there are discussions that we bring in this proposal of the framework legislatively, the centrality of the rights of the affected people, which is something that advanced a lot in the tragedies of Brumadinho and Mariana. At the same time, we are working with that in the seminar, advancing the protocols of previous informed consultation. And there's a strong debate in Brazil about public hearings, mechanisms of participation. So it's an innovative character of a difficult framework legislation, but we have a background here, the Convention of Tobacco, that says that transnational companies could not participate in the debate of this convention. And we have to lift that veil in this dispute. This is something that we must face to organize this pressure, accept this invitation made by Gustavo that we all engage into that struggle, but at the same time to announce that there's nothing new in the international field of human rights, because otherwise we will think that it's all very innovative and difficult, and at the same time something that we have addressed recently in OMA, which is this challenge that create a new language with a more concrete language for the national legislation domain, less generic. So there is this challenge of this dispute incorporating this agenda. So it's important to recognize how transnational companies operate, it's important to make it clear that we need further mechanisms to access justice so we can bring this to this framework legislation. Of course, this is only the first challenge. I think that if we get engaged into a political debate and to move on with this debate, this is what will happen. Just like it happened in Brumadinho and Mariana, we will take it to the field of the dispute on the agreements, the custody on the remediation, and this is something that we still need to do, still to be done. Thank you. Philip Fire has raised his hand. And Chena, I want to talk about some points that you raised. Does this law provide for the creation of new obligations for companies, for the state, for how do we solve that? So Felipe, I will pass the floor to you and you try to answer to these questions in your speech. Well, first of all, good afternoon, Gonçalo and everyone. It's a pleasure to be with you here. What we have been discussing about this framework legislation, it's been a while now that we have been talking about the systemic treatment for human rights in businesses in Brazil. We had an attempt. We cannot even call it an attempt. But complete lack of consideration of what had been happening from this new decree using authoritarian approach and brought to Brazil this topic in an acritical approach due to the absence of participation of the civil society. So ignoring demands from social movements and ignoring also all the technical knowledge that was built with the technical note number 7 that was already mentioned by Professor Manuela, presented in Brazilian right after the hearing that we had in Espírito Santo in the context of the balance of 2 years of the accident with the dam burst. Today we have a policy that bets on certification seals, codes of good conduct for companies, and does not go into the establishment of effective obligations, something that is already common sense in the international field. And with that, we have established that this certification seals could be implemented by the ministry. It has not been regulated yet to the degree, but we know that it will happen. And we know that this is completely insufficient, given the fact that Samarco, for example, had environmental certification related to environmental responsibility. So as much as the context is difficult, we need to do that through collective construction to create a framework legislation, something that can establish this direct obligations for companies that are based in the principles that have been built based on legislation number 5. And this was object of a collective construction in the National Council of Human Rights involving different organizations, including CUT, that contributed with a number of covenants about precarious labor, decent labor, with different judiciary agencies participating in the Ministry of Labor. This can be reproduced in a future draft of law with specific principles that will create obligations for the state, who is responsible for protecting human laws, prevention of violations, but also obligations to companies. And that's where we have a very clear failure on the side of the degree, not establishing direct obligations for companies. In addition to that, mechanisms of prevention that China reminded us of the existence of the principle of the centrality of suffering of victims. This was touched upon by the decree, but when we talk of a draft of a framework legislation, we cannot be limited by the specific situation of the dams, but also slave labor, threats to originary peoples, aggression to minorities, and other violations of human rights that will protect then the affected stakeholders and put these people in the center role, determining how reparation projects should be held, and so that violations are not repeated, providing prevention so that these violations do not happen again. Among these prevention measures thought in this potential draft of law, we could use some that are already being used. For example, one that recognizes the existing structural inequality between the different stakeholders. When we talk about roundtables and conciliation, this was something that was even mentioned in some parts of the seminar. There's a disparity of forces, and as it is the case of Brumadinho, where the people that were affected could not participate in the creation of the solution. This was reflected as an inequality in the reparation, as most of the funds were directed to the government of Minas Gerais and not to the affected people. So there are some measures, training for civil servants, mechanisms of access to information, attribution of instances in the participatory process that will not be captured by the corporate power, and with the direct obligation of immediate suspension of public partnerships, tax incentives, and administrative partnerships in general with companies that are involved in this disaster. Sometimes companies use these cases for positive advertisement of these initiatives. This can be also part of a potential draft of law on the side of reparation, so that we can keep companies from using their actions as a positive advertisement for them. This is changing the focus of the process instead of a compensatory approach to an approach that is more based on reparation of the affected parties. So the structure was based on that. The obligations established for companies, and especially for companies recognizing that they may violate human rights, and also prevention and reparation, involving the impossibility of always using negotiation methods, ignoring the disparity of forces. Thank you, Felipe. I don't see any more questions.
Andressa Soares. Muito bem, Andressa.
Gente, desculpa se eu caio.
Andres asks for the floor. I'm sorry if my connection drops, but I want to ask a question about Fernandes and Gustavo's experience. What are the paths that you think we should follow for this draft of law to get more parliament support, or try to disseminate that in civil society, to create a strong social society group? Because we know that launching the projects is just the first challenge. Then we have the challenge of making it grow. So as parliament assistant and Fernanda as a person who works with unions, how do you see that? So I invite Fernanda and Gustavo to answer and also for your closing remarks.
Posso falar então rapidinho ou Fernanda, você quer ir?
Mais próximo, por favor. Se aproxima.
Please, Gustavo, yes. Can you hear me?
Ou tá ruim? Vocês estão me ouvindo? Ah,
Can you hear me? Yes.
bom, essa pergunta, ela não tem uma resposta muito pronta, né? Assim,
Well, this question, we don't have a ready answer for that question. We'll have to build paths. My master's degree was on technologies for democratic expansion. I don't know if you know the history of Gabinete Toma, but here in Belo Horizonte, it was the result of a collective campaign that led to the election of Auren Cida as for the city council, and they decided to put down all the partitionings of the physical space in their office to create a one single room for everybody to work together. So all of this issue is based on the appropriation of politicians. We developed a project called LabPOP. All of these drafts of law, they had a technical juridical side, but also the discussion with the civil society. Of course, that when we talk about a draft of law at the municipal level, it's relatively easier because these are local topics and we have a certain capillarity in the territory. When we talk about highly complex drafts of law, such as this one, and when we take it to the international law, even if it's in the area of human rights, in some situations, we have a loss of territoriality. So we must join the social movements that are already in this area, civil society organizations, the third sector, and to create a methodology about this territorial discussion. That, from the technical point of view, maybe we will not be able to add, but we must translate our struggles and our the desires of people who are suffering their territories to translate it to a more technical language. This will be made by attorneys, by parliament assistants. So I think that the idea is to establish a methodology. For example, we can think maybe in a leaflet, how to discuss the project in your territory. And then people can carry out this debate. And why not in a public school in the state of Bahia, if a teacher wants to hold this debate and they can send us the result. This transfer this discussions to society and also create mobilization around the project. This popular mobilization, I have always I was always focused on minority in my parliament work. So we, from 41 representatives in the city council, we had 6 in a broad spectrum of left-wing politicians. In the House of Representatives, it's a disaster. We don't have almost no representativeness. So if we don't have popular articulation, and then also the contribution of the media it will be very hard for us to have this debate. But at the same time, we must qualify the debate and try to understand our limitations, what we can do, what we cannot do. Also, the urgency of this process is very high. So I think we should try to strengthen this mobilization. and participation
Quando o
in
projeto de lei da Câmara Municipal chegar
the creation of this draft. For example, when a draft of law comes through popular proposal, the city council members, they feel compelled to approve it. If a draft is proposed by a minority, Áurea and Fernanda, they don't have much power. And this is different from having a draft proposed by popular initiative. I'm not saying that that's the solution, but this would be a strategy that in the Belo Horizonte House of Representatives would be very effective. So I think we should think along these lines. So by closing, I want to thank you for the debate. This is an important moment for us to make this process even more radical. You can count on me, and also you can count on the representative Áurea Carolina to also to promote this work. Thank you, Gustavo, for your engagement. And let's work together. My position is very much aligned with Gustavo. Our more effective experiences in the National Congress in these last 5 years were those who were supported by more social mobilization and that had more understanding on the side of society. The labor reform, exactly due to the lack of direct connection by the people, it engaged much less people than the social security reform. And then our ability to resist, of course, we are living a very unfavorable context, but our capacity to avoid even greater advancements was more effective when we had more society engaged around these topics. Another example is the National Campaign for the Right to Education that managed to establish important achievements in our last mandate. So I reinforce what Gustavo said, the importance of the mobilization of society in general around the topic. And in order to get that, so that people understand what is being said. Another important articulation in the defense of social rights are the creation of parliament fronts that allow for a greater articulation and engagement of this ample fronts, as Gustavo mentioned, and considering, of course, that elections will be held last year, but considering what happened in recent years, this kind of articulation inside the parliament and outside the parliament with pressure from society is very important. From the point of view of the union movement, there's a growing awareness about the importance of these instruments, especially because of the context in which we're living. The need to resort to multilateral institutions such as the ILO and the UN. In addition to this effort of mobilization, we need to strengthen and to put base union movements and projects such as this closer. We need to bring them closer together with the academia. So we'll have more support when these resources will be even more necessary. for us to defend even the 1998 Constitution. So on behalf of CUT and I would like to thank you recognizing the importance of the seminar and especially this panel. So I thank you. And I say goodbye, convinced that this is another campaign where we will be together.
Muchísimo obrigado, Fernanda.
Thank you, Fernanda.
No chat, não estou achando uma das perguntas que parece que tem. Não sei onde está.
I think there are more questions, but I can't find them.
Não estou vendo aqui no chat. Achei. Eu vou responder essa pergunta.
I will answer to this question.
Diz assim,
The question says,
boa tarde. Gostaria de saber a opinião
Good
dos
afternoon.
panelistas
I'd like to know the
se
opinion of the
algum
panelists
trabalho crítico junto a
if it would
demais
be
parlamentares
good
para
to have a
facilitar melhor
critical
compreensão desse processo,
work with other
como a falha dos
parliamentarians
princípios orientadores, complementando
to
a
speak
pergunta.
about the failings of the guiding principles, for instance.
Não, então,
So
essas são as táticas e
these
as
are
estratégias, né?
the tactics and the strategies.
Ao meu
I,
ver, essa é a minha opinião,
this is my
nós temos que
opinion,
nos concentrarmos no,
we should concentrate,
ou seja, nós temos que tipo tentar despojar
try to
o processo de questões
separate the
objetivas.
process from
Nós sabemos
subjective
que é
questions.
impossível, mas
We know it's impossible, but as much as possible, try to
ali, ao
to
invés de ir para debate,
so instead of going
que é
to a
debate
debate,
internacional, que
which is
é
the
a
international
Comissão
debate
Europea, que é
about due diligence,
a briga entre o tratado e os princípios norteadores,
the idea between guiding principles versus the treaty,
esse debate traduzido
to bring to the debate, translate it into what the reality of violations is in the territories. That, to me, is the only way that can mobilize and give legitimacy and for which the law is important. So, the law is not worth it to bring it to something that has strong grounding and deeply rooted in Brazilian society. So if somebody wants to bring the international debate, bring it, but we have to do our homework. We need a law because Brazil needs a law, because otherwise, to a certain extent, we'll be bringing logics that are foreign to our reality to produce a law and the Brazilian citizenry and the affected communities particularly need this law. So this strategy is the strategy that connects the Congress people with their constituents, with their territories. So you mustn't lose sight of this. So Congress people have to win votes, right? So these are the people that elected them. So people that elected them are not interested in the treaty versus the guiding principles. They're thinking about the violations that are happening on the ground. So how the mining company is fouling the rivers, or how the phone company is charging too much, or how the soya monoculture is poisoning their water. That's the kind of thing that people are concerned about, and we have to build a majority based on that. So of course we have the experience, but to add conflict that are not part of the Brazilian nature to a debate that is already conflictive, it wouldn't be the best strategy. So this idea of the law being rooted in the problems that there are actually exist in Brazil and the violations that take place at the bottom of the pyramid, on the ground. There's other strategies, you know, about opportunity, when it should be put before parliament. That's more of a technical. If we build a law that the affected populations need, then the problem is solved. Then we'll have the legitimacy that we need to be able to advance. I was going to conclude, but so that's it from me. I hand over to Professor Manuela Holland for her remarks and perhaps conclusion. And I thank Gustavo, Fernanda, and all the parliamentary aides that helped, also the Homa people, the FES people that made it possible, and Claudia, Fernando that helped put all of this together. I didn't cut my hair, so you can see my ponytail. Anyway, I just want to compliment. We ended up having a shorter a panel because of the absence of the Congress people. We have resolution number 5 of the National Human Rights Council. It's a tool. It's something that can resonate the voices of the affected people. If you read resolution number 5, it's very clear the differences between the decree 9571 and other government initiatives. So it would be important to at least disseminate more the resolution. It's already passed by the council. So rather than saying no to this or no to that, there's something we can say yes to, resolution number 5. And a lot of work went into its formulation. So that would be an important communication strategy. So we're not speaking out of the blue. So on behalf of Homa, I want to thank you all, Fernanda, Gustavo, Gonzalo, everybody who's present here listening to us, to the interpreters, to all the Homa members, our students, our researchers. We spent the whole week here. There were also some evening events. So we're always doing our best at Homa to open up spaces for different voices, this multiplicity of voices. Sometimes we advance more, sometimes we advance less, because when we come closer to the nucleus of power and there's the possibility of change, then more and more complex tools are required. You know, the Brazilian state has its own rituals and requirements, etc. So it's a construct. We're together. We can add our efforts more than ever before. Thank you, everyone.